Welcome to Case Flash, brought to you by the CBA Family Law Section. I'm Sam Schoonmaker, and with me today are attorneys Campbell Barrett and Jill Blanchard. Today's Case Flash addresses custody evaluations, procedural due process, and the Supreme Court's decision in Barros v. Barros. First, the basic facts. The parties' 2010 separation agreement provided for joint legal custody and primary residential custody with the plaintiff mother. 1 year after the marital dissolution, the defendant moved to modify custody and filed a motion to refer to the Family Relations Office. The parties stipulated to a comprehensive custody evaluation by Family Services. The defendant appeared for the initial appointment with his attorney, and the FRO indicated they would not allow the attorney to participate. The trial court immediately addressed the dispute and indicated that if the defendant didn't want to participate with FRO, he wouldn't be forced to do so against his wishes, and it canceled the evaluation. The defendant then filed a motion to participate in FRO with his attorney present. The trial court denied the motion and ordered a private custody evaluation at the defendant's expense. The defendant filed a public interest appeal, and the Supreme Court took the appeal and affirmed. Attorney Blanchard, what was the liberty interest involved in this case?
The liberty interest is the fundamental right of a parent to make decisions regarding the care, custody, and control of his or her child. It's a fundamental liberty interest that's been determined by the Supreme Court and the Connecticut Supreme Court to be protected by procedural due process, and therefore it's a significant right that this court in Barros accepted as requiring the state to ensure procedural due process to the father when it denied the right of the father to have access to the evaluation process with his attorney present.
Okay. So, Attorney Barrett, the Supreme Court applied the well-known Matthews test here. You know, the first prong being the private interest involved, the second prong being the risk of an erroneous deprivation under the existing procedures, and the third prong being the governmental interest involved in the case. How did the Supreme Court apply the test to the Barros situation?
The court looked to a number of different questions and questioned whether or not the presence of counsel would enhance the evaluation or not. And the court determined that there was no risk of a deprivation of the right by excluding counsel, and that the lawyer would still have the right to meet and prepare with the client, to go over the questionnaire with the client, and that the lawyer could cross-examine the custody evaluator at the time of trial. And critically, the court noted that the evaluation is just one piece of data, and it's not necessarily determinative of what a court will do, and a court is free to reject the evaluation. And the court found that the presence of the lawyer just wouldn't enhance the process, and that in fact might interfere and stifle some of the candid participation of the parties. And for the third part of the test, the court found that the state has an interest in custody adjudication procedures that facilitate accurate determinations of best interest, and that the present test accurately balanced all of the competing interests.
What was the FRO's role in this case, and what is it generally in custody cases?
I'm going to do it reverse. So generally, the Family Relations Office will assist families in trying to reach a mediated solution when those families appear in court, either during the pendente stage of the case or toward the end of the case. If they're appearing in court, let's say on a show cause order for custody, that might be even a final agreement. But in this case, the Family Relations Office was conducting an evaluation of the family. It's not a mediation type arrangement, but rather it's an investigatory type study where the Family Relations Office will meet with the parties, meet with the children, speak to collateral sources, reach its own conclusions about what is in the best interest of the children, and eventually prepare an evaluative report.
So why did the attorney want to be there for this case, and what role did he think he was going to play?
There were a couple of factors that were discussed in the decision. And first, the lawyer articulated a concern that Family Relations would simply try to induce settlement and not allow the litigation process to go forward. And there's a very interesting discussion in footnote 12 of the decision where the father's lawyer said there's going to be an interview by a state agency involving the claims that the father was driving under the influence of drugs or alcohol in the car, and that the lay father needed to have the right of counsel because he had certain rights and privileges that he may not be familiar with. And the court rejected that and said the central focus is the best interest of the children, and that by having the lawyer in the room with that agenda, it might impede the reliability of the data gathering from the family relations officer. And that really was the articulated basis in the decision that the father's lawyer had for why he wanted to be in the process.
Yeah. In your experience, are there a lot of attorneys who want to participate in the FRO process from the very beginning at every stage?
In my experience, attorneys do participate at the Family Relations Office when it is a mediation type arrangement. When you appear at short calendar and you refer to family services for mediation or to try to resolve the dispute that's there in court on that day, attorneys do participate, and they appropriately participate because it is one arm of the court that is attempting to use the services of the attorneys that are there with the parties that are there to try to reach a negotiated settlement. But it is also my experience that attorneys do not participate at the evaluation stage of a case, that it's well understood that parties will participate by themselves with the family relations officer who is doing a fact-based analysis.
Attorney Barrett, do you think it would have made a difference here if this were a third-party case?
I think it would have changed the analysis slightly, but I think the end result still would have been the same. If you put that fact pattern into the three-prong Matthews test, you might get a different answer on the first prong. Because in the Barros case, the court looked to the fact that the parties, the two parents, both had equal rights to assert for the parenting of the children, and that they canceled one another out, and that all that was left was that question of best interest. And it cites to the Fish versus Fish case for that proposition. But Fish went further to say, in a case where you don't have two parents, which have equal rights, where you have a parent and then a third party, they're not at equal poise, and that perhaps it should be weighted a little bit differently in the parent's favor. So that might impact, under a Matthews analysis, that might impact the scope of the private interest involved, and maybe a parent had a right to not just an evaluation that led to best interest, but maybe it was a little more weighted in their favor. But then if you get to the second prong of the Matthews test, when the court talks about whether a lawyer would enhance the process and how the right would be deprived, and I think you'd come to the same result. I think you would get to the same result in that second prong of the test, and that you really wouldn't have overall a different outcome.
Attorney Barrett, do you think that this Barros case is a significant decision?
I think it is an interesting decision, and I think that it sets forth some broad themes regarding due process rights, and that I think could be applied to other cases. So I think, quite frankly, it answers a question that perhaps had been unanswered. So there really is no question now that family relations can keep a lawyer out. So I think it's a helpful decision from an intellectual standpoint as well as from a practical one.
Attorney Plansher, do you see any equal access to justice issues involved in this case that would affect the kinds of cases that Connecticut Legal Services sees?
That's an interesting question. You know, I thought about that when I read Barros for the first time, because obviously persons who can't afford counsel are not entitled to counsel, period. So arguing that a person is entitled to counsel at a stage of an evaluation seemed to me to be somewhat of a stretch in light of the fact that a person isn't even entitled to counsel in a civil matter. With regard to access to justice, I'm not sure that that's what this case is about. I think this case is more about ensuring that the best interest of children is served by the procedure that the Family Relations Office is using, and I think it's clear that the Supreme Court determined that it is ensuring the best interest of children by determining that counsel shouldn't be present during the evaluation process. So I'm not sure it's an equal access to justice case.
Attorney Plansher, what does this case say about the value of attorneys participating in the evaluation process?
Well, I think it's a pretty strong opinion that attorneys are not considered valuable by the Supreme Court in this type of analysis and an evaluation. I have some concerns with that.
Is that because it's fact gathering? Is that the reason for their the diminishing of the attorney's role in this aspect?
I think so. I mean, I think the court said that the intrinsic value of having an attorney there is not to assist in fact gathering, but rather an attorney's value is in the negotiation stage of a case or argument to the court or in the opportunity to cross-examine a family relations officer if he or she is testifying in court. My concern, though, is that there are times when persons who are represented by counsel, whose counsel cannot participate, are unable to articulate what is truly a concern to them regarding their children, either because that person has been undereducated or because that person has been subjected to domestic violence during the course of the marriage or the relationship with the parent, so that that person might not be in a position to fairly articulate his or her own concerns and would benefit from counsel being present. So having a bright line test like this does provide me with some concern.
What I thought was very interesting in that regard was the discussion by the Supreme Court that not only would the presence of counsel not enhance the process, but it would likely hurt the process. And that the role of the evaluator is as a neutral, and it is as a fact gatherer, and to find out all the facts, ferret out all the facts to lead to a determination of best interests of the children, and that a lawyer being there would spin the data in such a way that perhaps the evaluator wouldn't get a true look at the facts that would lead to that determination of best interest. So I thought that was a very interesting and maybe even jaded view of what we do as lawyers by the court.
Do you think that it might have been a different outcome if this were a domestic violence case, where a party really needed the assistance of counsel with the Family Relations Office?
I'll take that one. That hasn't been my experience. In fact, it has been my experience that the only distinction made by the Family Relations Office is whether or not they'll meet with the parties together. So if there is an existing restraining order or protective order, they will meet with the mother and father separately, even in this evaluative process, because they don't want to re-victimize the victim of domestic violence by putting them in the same room during an evaluation. But they still don't invite counsel into the table.
In this case, the trial court sent this matter for a private custody evaluation. Do you think that this decision impacts in any way the way private custody evaluations are conducted?
No, not at all. I think that the analysis in the case is limited to the family relations evaluations where there is a state action. And if you have a private evaluator, you no longer have that state action, so there's no longer a due process consideration.
So there's no real argument here that an attorney has a right to participate in a private custody evaluation.
It's up to the evaluator.
It's up to the evaluator.
And then there wouldn't be a due process question.
The Barros decision is a significant case for anyone who practices custody cases in the Superior Court. Thank you for watching Case Flash.